You've been involved in many high-profile cases, probably none greater than the Ben Roberts-Smith, who sued Channel 9, or 9, the company, over its war crimes stories. Millions of dollars were at stake, as well as the reputations of the organisation and the journalists involved. It was a huge win in the end, which is now being appealed, that decision. How do you cope with the pressure of such a monumental case?
The pressures in that case were extraordinary because, number one, we had been involved with Nick Mackenzie in the pre-publication, and we had gone through story after story, hundreds and thousands of documents, photographs, we'd spoken to witnesses, etc. So that added some pressure. But then these were well-resourced stories, really well-resourced stories, research stories. But when you then look at actually trying to get witnesses into the witness box, that's a challenge. No one is anxious to get into the witness box. And so we then had to work with the reporters. We had to talk to the SAS soldiers and their lawyers. We had to talk to Ben Roberts-Smith's wife and his private investigator, and also witnesses, potential witnesses in Afghanistan, and try and influence them to step into the witness box. It was extraordinary that 22 SAS soldiers actually agreed to get into the box and gave evidence. It was extraordinary that Ben Roberts-Smith's wife, who was listed to give evidence for him, actually gave evidence for us. His private investigator, again very reluctant to give evidence, got into the witness box. Huge, huge challenge. Added to that, we had unlimited resources thrown at us by Ben Roberts-Smith and his legal team, funded by Kerry Stokes. Hundreds of subpoenas and notices to produce. I personally, I think, swore about 30 affidavits. I was cross-examined twice, which I can tell you is not pleasant. They had 4 silk from time to time in that case. We only had 1. So the pressures on the legal team was huge.
Were there moments that you feared you may lose the case?
Well, every day it was a challenge. Every day we had a judge. 110 days this trial lasted for. The judge gave no indication in that 110 days which way he was leaning. So I was very, very nervous. We had some days, many days, where our witnesses were doing very, very well, and we did pretty well against their witnesses. There were some days where we didn't do as well. So you would have these highs and lows, but there were many days I thought that maybe we weren't going to win. At the end of the trial, I spoke to our team and said, well, I'm confident that we haven't left a stone unturned. We have done every single thing, working with Nick Mackenzie, working with Chris Masters. We have done every possible thing to try and win this case with 3 brilliant barristers, Nick Owens, Lindell Barnett and Chris Mitchell, brilliant barristers. So we did everything we possibly could, but then we had to wait something like 9 months for the judgment, and having no idea really how the judge was going to decide it, knowing that the burden was on us, knowing we had to prove murders in Afghanistan. A huge challenge.
So I believe you burst into tears on hearing Justice Anthony Basanko's ruling. Is that right?
Well, it is true. I was actually in Iceland, and it was 4 a.m. in the morning, and I was in the reception of this hotel with only a receptionist sitting there. It was daylight being in Iceland, but I watched this, and Justice Basanko went on and on and on for 20 minutes or half an hour with all the preliminary stuff. And then suddenly it dawned on me that we had had this extraordinary comprehensive win. And I just literally burst into tears. And so the Australian Financial Review ran this article headlined, "Tears in Iceland." And I'm told by the AFR that it got more hits than a lot of the other articles they published that year. But it just impacted, and I'm not a person that bursts into tears too often, but my wife was upstairs in the hotel, and so I then tried to compose myself, went upstairs because she wanted to know the result. I sat on the bed for about half an hour in uncontrollable tears, and she thought we'd had a comprehensive loss. And then I was able to get across that we had won. It was a wonderful vindication of quality journalism by Nick McKenzie and Chris Masters, and quality work done by the legal team.
I think it would have had an impact on investigative journalism in the country had that case been lost. Would you agree with that?
I totally agree. I first of all, the actual defendants in the matter were the Melbourne Age, the Sydney Morning Herald, the Canberra Times, and the reporters. It was only soon after Ben Roberts-Smith issued the proceedings that Nine took over Fairfax Media. To this day, I wonder whether Fairfax Media could have afforded to defend that case, because our costs were in excess of $15 million. Did they have the deep pocket? But if they had lost that case, I think it would have been a difference of $25 to $30 million for Nine. They would have had to pay the costs of Ben Roberts-Smith, and his costs would have been in excess of $17 million. They would have had to pay damages, and the damages would have been significant because we kept publishing after he issued proceedings. So it would have been, and they'd have to pay their own costs, of course. And to me, if that had happened, it probably would have led to retrenchments. It probably would have meant lawyers, in-house lawyers who are doing pre-publication in all media companies would be even more nervous pre-publication. It would have meant they would have been more nervous once they got a letter of demand, and more likely to try and compromise on a commercial basis. It would have meant that reporters would have been more nervous about being sued and self-censor, and that would have been terrible for freedom of speech in this country.
Did it help that the reporters, Nick McKenzie and Chris Masters, had fantastic records, fantastic access to sources, and working closely with them must have been quite an experience?
Well, it's an experience. I've worked with Nick McKenzie ever since he started work at The Age, and we've had so many challenges over the years. He is quality. He is pure quality. Chris Masters is pure quality. And I think if these stories had not been as well researched, if we didn't have the same quality of journalists, then the result could have been far different.
I should add a plug here, whether we use this or not, but both Nick McKenzie and Chris Masters' interviews are available on Democracy's Watchdog's website, so check them out if you haven't seen them before.
And I can recommend them. I've watched them, and both are amazing, amazing reporters. And you know, one of the incredible things during my career is that I've had the pleasure, the honour of working with some of the best reporters this country's ever produced.
Can I just move on to the national security laws, suppression orders and other laws that seem to impact on the public's right to know and free speech? How much of a restriction do you think there is on both of those, free speech and the public right to know, due to these laws?
Well, I think it's a huge challenge. National security, we all acknowledge that there are some areas where the media should not go and should not publish in, like, terrorism investigations or whatever. So there are some legitimate and plainly legitimate areas where the media should not be publishing, but they need to be limited, where you get government employees who are very sensitive about various issues and try and self-censor. And we've seen it so many times. We saw it early part of my career, the ANZUS Papers case, where the Commonwealth took out an injunction in the High Court to restrain the Age and Sydney Morning Herald publishing ANZUS Papers documents, and lost, I might say. I think they took out the injunction on about 7 or 8 different issues, and we won 7 of the 8. But you see that quite often. You've seen it in the BRS case, for example. The Commonwealth was represented in court every day. They probably had 5 or 7 or 8 people in court every single day, 110 days. So people talk about the costs of the BRS case being something like $30 million. That doesn't include the costs of the Commonwealth. We had, in that particular case, we had to get security clearances. We had to have a secure room in the Minter-Ellison Melbourne office, the Minter-Ellison Sydney office. We had to have Defence Department safes and laptops. We weren't allowed to have a lot of documents on our systems. It was a huge challenge. We had 45 pages of Section 38 restrictions of what we could and couldn't do. We had a separate closed court where we had an open court on level 21 of the Federal Court in Sydney, and then had to physically move to another court where we had to give up our laptops, even our smartphones, even our watches. We couldn't really take notes in there. The security documents, Ben Roberts-Smith had access to some documents, some important documents, unrestricted, but ours were redacted. So, huge challenges.
Yeah. Why did that happen? How sensitive were these documents? I mean, what was the issue? It's hard for someone from the outside to see why these measures were necessary.
Well, I think the Defence Department was sensitive about how they operate in the war zone. So there are clearly some sensitive areas that we needed to be very careful about. And they had a barrister, sometimes a silk, senior counsel, sitting in court, who would stand up and say that's sort of a no-go area, it should be in closed court. All of the SAS soldiers, for example, had pseudonyms, and I think we went from witness 1 to witness 135 or something. We had to have the soldiers in hotels and then get a car to take them into the court building through the judge's car park and up through the service lift or the judge's lift to get into the court, so they wouldn't be filmed going into court. So the identities of SAS soldiers, I think, were quite properly protected.
You've spent decades defending media against defamation claims. What do you think about Australia's defamation laws as they stand today?
Well, Bill, it's interesting you raise that, because the defamation laws are very pro-plaintiff. We've seen through the 1970s and 80s a real move for uniformity. So every state and territory had different defamation laws. We got in 2005 uniformity, and that I think was a huge improvement because now the state and territory borders are irrelevant to the media. And so that was a huge improvement, but they are still very pro-plaintiff, and that's a huge challenge for the media especially.
There were some reforms introduced in 2021, and I refer to things such as public interest defence, and also that the plaintiff has to have suffered serious harm. Have they made a difference?
They haven't made a difference as yet because there haven't been too many cases decided, but we're pleading them. We've argued those defences in recent cases. But a real problem, I think, with the 2021 reforms is that it hasn't been adopted by every state and territory. So they haven't been adopted by WA or the Northern Territory. So to that degree, we're moving a little further away from uniformity.
Why is that?
I think those parliaments just have decided not to adopt those reforms as yet. And it has meant that there's been some forum shopping. We've had a couple of cases that have been issued in Western Australia, in Perth, that actually could have been issued in Melbourne or Sydney. And that's not ideal.
Okay. We still have this weird system in Australia where the burden of proof exists, and that means that the media have to prove in court that what they published was true, rather than the plaintiff proving that it was false. Is that still an issue?
It's a huge issue. It's a huge issue. So we've had a couple of recent cases, obviously the Ben Roberts-Smith matter. The burden was on us to prove truth in a civil court before a judge normally hearing commercial matters, that Australia's most decorated war hero, the public face of the Defence Department, was involved with war crimes in Afghanistan. Huge challenge.
Why do we have that burden of proof reversal in Australia? It seems weird when every other law seems to suggest the opposite.
Well, every other law does suggest the opposite, that the burden's normally on the plaintiff. But I think it's following the English tradition, that it's always been the position here. And it is very difficult for the media. And I think a lot of very doubtful characters over the years have taken full advantage of it, thinking that witnesses will not get in the witness box, and on that basis they're likely to win, or the media will take the view that they can't prove the allegations in open court and therefore settle on a commercial basis.
With the rivers of gold that traditional media depended on kind of evaporating or evaporated, and defamation costing, say, about $150,000 a week, and knowing that some plaintiffs are either being funded by billionaires or by wealthy people, and that the media seldom win, have those factors had an impact on the amount of investigative journalism being done in Australia?
Well, it's an interesting question because there were the rivers of gold. I remember having a couple of the most expensive lunches I've ever had in London with reporters with unlimited expense accounts. Those days have gone. We've now seen so many retrenchments, and it's a lot more difficult for the media now. The costs in defamation actions are extraordinary. They're outrageous. What did you say, 150,000
a week?
A week, far more. You'd get senior counsel charging 12,000 a day. One I've heard of charges 35 a day in appeal cases. So the costs are outrageous. The media simply cannot afford it. And that means that where you get a plaintiff that's funded by a billionaire, or a plaintiff who themselves has unlimited resources, it's very difficult for the media to counter that.
It is. Do you think it's impacted the amount of investigative journalism that media do?
Well, I think it has, but you really have to admire the major mainstream media in Australia that have supported investigative reporters. I think the Nine Network, the Seven Network, News Limited, the ABC are still supporting investigative reporters, and that makes a huge difference. You know, going back again to the Ben Roberts-Smith matter, the Nine Network were getting obscene bills every single month, bills they had never seen before, month after month after month. But their support for the defence of that case was unwavering.
How can journalists best protect their sources?
The sources is a huge area. You cannot have freedom of speech. You cannot support the public's right to know if you have a regime where journalists can be ordered to disclose sources. So, you know, we mentioned Nick McKenzie, for example. I think at least 6 times people have tried to get, through the court process, access to Nick McKenzie's sources. We actually had in the security issues a subsidiary of the Reserve Bank, an order that Nick McKenzie and Richard Baker disclose sources. And then we hear on the grapevine that a message came from the prison that, oh, these are nice, good-looking young men. We're looking forward to seeing them coming here. It just sends a shiver down your spine. You cannot really guarantee freedom of speech without protecting sources. So now we have a regime in the states and territories and the Commonwealth where there are shield laws. And so we've relied on those shield laws, and those shield laws have stood up very well. For example, Adele Ferguson was successful against Gina Rinehart in the Supreme Court of Western Australia in not having to disclose sources. It's a very important area. The problem is all the states and territories in the Commonwealth, their legislation is not uniform. And in addition to that, there's the ultimate right of the judge to decide whether it's in the interests of justice that the sources be disclosed. So the risk is still there, but we've now got some reasonable legislation.
We've just had a privacy tort introduced in legislation. Do you think that'll impact on journalism and freedom of speech, in your view?
Well, it's an interesting area, really, because for the last 20, 30 years, there have been people lobbying for a tort of privacy. We've always opposed it. We've always taken the view that it would be like cracking a nut with a sledgehammer. The High Court of Australia recognised 20, 30 years ago that in some circumstances there could be a tort of privacy. The Victorian County Court, for example, has decided a couple of times that there is a tort of privacy, but it's never been adopted by a superior court. But now the Attorney General has said that we're going to get a statutory tort of privacy. It will have a significant impact, but there is an exemption for the media, and that is huge. That is so important, because how can the media publish? You pick up the newspapers every day, you look at social media every day, you look at television every day. There are arguments that something or other that's been published would breach someone's privacy. So if the media was exposed, that would have a huge impact on freedom of speech.
I believe journalists are exempt from the legislation. However, sources giving material to journalists, citizen journalists, and possibly even satirists are not exempt. Is that correct?
I think that is correct, but you know, there will be, it'll take years to get cases through the courts to actually find the limits of this legislation. But I think the exemption for journalists is crucial. And then whether the sources and others can also seek protection, time will tell.
A journalism lecturer at RMIT, Josie Vine, contacted me when I told her that I'd be speaking to you. She wanted to ask about privilege and as it applies to local government, local council reporting, particularly recordings of council deliberations.
Well, it's an interesting issue, and it's an issue that really hasn't been tested in the courts too much. I think the greatest exposure for local government councillors is using social media. And there have been a number of recent cases where councillors have been sued for what they've put on social media and have lost those defamation cases. And that has cost them dearly.
So what about reporters, though, covering council meetings? Is there any privilege that applies to those reports?
I don't think there is. I don't think there is, which I find surprising. That you would have thought that the deliberations of a local council should be privileged. But it's strange that there are very few cases that cover that area.
Do you see yourself being independent from the reporters, or what's the relationship between you as a media lawyer and a journalist?
Well, I think over the years it's changed totally. When I started work, I think it was a bit of a them and us between the reporters and the lawyers, that the journalists would tell us enough to get the lawyers' approval to publish. Now I think the journalists realise that actually we need to work together. They need to let us know where they see the risks, where they're on stronger ground, where they've got multiple sources, etc. Because the consequences of actually being threatened or being sued are huge. And so it's more now a team relationship, so that you work very, very closely with the reporter and need to work very closely with the reporter, but still be totally, utterly independent as the lawyer.
Do you sometimes need to tell them to go and keep digging?
Absolutely. There have been many, many stories that have been through 20, 30 drafts. I remember the Jeff Clark stories, for example, with Andrew Rule, again, a brilliant reporter. The first time I saw that, I said, well, that can never be published, because these were serious allegations against Jeff Clark, a very well-known Indigenous leader. And that story went through many, many drafts. And Andrew went back and back and back and was digging further and getting more and more sources. And that story was then published.
Those allegations involved rape, right?
Those allegations involved rape. And that story, up until recently, was the most decorated story ever published in this country. It won the Quill Award, the Gold Quill, the Perkin, the Walkley, the Gold Walkley. An extraordinary story.
Andrew Rule's on Democracy's Watchdogs as well, so, so there you go. So there must be moments where there's tension between the journalist's desire to publish and the law. How is that resolved? And have you had any memorable arguments, disagreements and so forth? Come on, Peter.
I have had so many debates with the reporter. No reporter likes any of their copy being changed pre-publication. So I would have that debate. The reporter often was not happy. And then I'd get someone from the news desk to phone and try and soften me up. And then I'd get the editor to try and phone and soften me up. But I think they all learned that I was there to negotiate, but if I said, no, you can't, then they would accept that. They never liked it, but they would accept it. And it's similar when a reporter's sued. They then become very nervous. They are taken away from their major job quite often to focus on the court case. They know that their reputation is at risk. They want the case to go away. But there have been many, many cases in which I've settled and paid money and agreed to a form of words, obviously on instructions. And the reporter then says, well, you should never have settled. But the reality is the last thing they wanted was a huge court case.
You've had such a wealth of experiences, Peter. It's been a fantastic career.
It's been a challenge, but a privilege to work on so many interesting cases and with such quality journalists, including, of course, yourself.
Too kind, Peter, too kind. I better end it there. Thank you. Just for the sake of transparency, I should acknowledge that Peter's law firm, Minter Ellison, provides pro bono legal advice to democracy's watchdogs, and that I've worked with Peter both as a reporter and an editor at The Age and the Sunday Age for many years.
Many years? You're not naming the years.
I'm not naming the years.
Better not to.
No. So basically for my entire career at The Age, of 33 years, I think you've been the go-to media lawyer there.
Well, I think I've seen probably in excess of 20 editors of The Age, plus all of the separate editors of the Sunday Age. And I think I've lasted longer than anyone.
Well done. Touch wood.
Touch wood.
Thanks, Peter.
Thanks, Bill.